Folks, we're back. This is Steve Sampson, Jim Jones for Veterans in Politics. Today we're going to have two exciting guests. We're going to have Tim Williams, Clark County District Court Judge, and Paul Padda, Nevada attorney, to discuss the Missouri Plan. And if anybody doesn't know what the Missouri Plan is, time you get done with this show, you're going to absolutely know what the Missouri Plan is. The show is brought to you by Ron Quince. Jim, you have anything?
No, actually, I just wanted to extend my thank you to both of you gentlemen for coming in. As we were talking a little bit before we started, Judge, this is something that Steve and I have been discussing this issue for the last 15 years. So I'm just very appreciative that you guys are coming in so we can have this important discussion.
Yeah, and thank you for inviting me. In fact, I think I've seen an evolution in Steve on some of these issues regarding whether judges should be elected or whether there should be some sort of Missouri plan.
It took a while.
It took a while, right? But yeah, and the thing about it is, and this is how I look at it, there's no 100% correct answer to it. And I think what we should look at it from this perspective, what you want to do is take politics out the best you can and take money out of it, right? And get good judges. But go ahead, Steve.
With that, Judge Tim Williams, could you give us a bio?
I've been a trial judge for 17 years on the district court bench. In 2006, I went through the appointment process. In fact, I went through it multiple times. I made the finalists 3 times, and ultimately in 2006, Kenny Gwynn appointed me to the bench.
So when's the first time you went through that process?
Probably within 2 years before that. I mean, it gets a little, but 2 years. And we'll talk about this a little bit too, but as you know, and you've said in it, and I think at that time I went through it wasn't public.
Right.
Today it's public, and it's a fairly rigorous process you have to go through.
And what does it entail?
It entails an application, and the application is fairly significant in this regard. What they do is they want to know everything about your entire life for the most part.
Right.
Where you went to high school, where you went to college, where you went to law school. They'll ask you questions like, what are the 5 most important cases you've worked on? They'll want to know what your experience is in the legal community, whether you had leadership positions, all sorts of things like that.
Any psychological evaluation, anything like that?
Well, I know this, they do a FBI background check on you.
Yeah.
They do that too. Mm-hmm. And so it's a fairly rigorous vetting process you have to go to, probably not much different than you would go through for a federal appointment, and and the thing about it too, the application in and of itself, and Steve, you've seen them, they're pretty intense, and I kind of look at it this way, and I think in a general sense, when you go through that process, and there's no guarantees, but you've been vetted, right? You've been vetted, and for example, do you got any tax liens? I remember that as a question. I could say, no, I don't, right? And they want to know if you paid your taxes, if you had any.
So they pull your credit report?
I don't know, but I bet they do. I wouldn't be surprised. I really wouldn't, But, when you think about it, I don't see a problem with that because in a general sense, if you're appointed as a member of the judiciary, here in the state of Nevada, you're put in a position of public trust. Right? And that's so important and it's so overlooked. And I think what's overlooked in one respect too is this. There's not really very much politics involved in that. And here's my point. I look at, and I guess it depends on the governor, but I know this, I almost know this with absolute certainty, with Kenny Gwynn, who appointed me. I think his record was 4 Democrats and 5 Republicans that he appointed to the bench, right? Mm-hmm. And that's how it should be. And what I really respected and admired about Kenny Gwynn, he kind of looked at the process this way, because I know he did this with Ken Corey, and who was a trial judge. He looked at it this way, and this was part of his decision-making process at the very end, because I had been a finalist 3 times, and he told Ken Corey the exact same thing. He said, well, you know what, they must really like you. They keep sending you back. They keep sending you back. And that's a reason for me to like you. 3 times is enough. I'm going to appoint you. And that's beautiful. And that's how it should be, because, and I think one thing that I don't know this for certain, but it seems to me that the number of applicants that apply for the judicial positions for whatever reason are going down. Mm-hmm. And maybe it's because people, we can talk about that a little bit.
I want to get your background.
Okay. Oh, all right. And we've gone through that. And I'm originally from Chicago. Okay. Grew up in the South Side. I'm a city kid. Went to.
Were you in any games?
No gangs.
He was in the library studying.
but I did go to a inner city high school, public school.
Okay.
Then after that, I graduated from Indiana University,
Okay.
and Ohio Northern University for law school. And I've been here for a long time. Moved here in '85. I mean, how many years is that? That's
About 37.
yeah.
No?
I
Because I came in 95.
right, and so I consider myself a native now.
Yeah.
I mean, after 25, right?
Yeah.
We're natives, And I've seen all the change, and I can say this: I've enjoyed my path here in Las Vegas. For me, it's been wonderful. It just has.
Mr. Padda?
Well, I'm the owner of a law firm, Padda Law. I moved here in 2004. I came here to join the U.S. Attorney's Office.
2004.
Yeah, I'm just a newbie. I came here to join the U.S. Attorney's Office, and then I started my own practice in 2010, 2011 timeframe. Been on my own since then, and I love Las Vegas. It's one of those cities that really just kind of grows on you. Like the judge, I'm not from Chicago, but I did go to school in Chicago.
Gangs?
I was not in a gang. No, I was, but I was a Chicago Bears fan. I'll put that on the table.
There you go.
It's not popular to admit that now that we have the Raiders, but I definitely.
I actually got a Raider hat here. I'm a Bears fan too, but I like the Raiders.
Okay, you support. Okay.
Hometown team.
Hometown team. And not to date myself, but Walter Payton was playing for the Bears when I was at the University of Chicago.
Right.
And I think he's the greatest football player of all time. An amazing guy, just on and off the court, field, I should say.
We haven't had a sports show here ever, have we?
Yeah.
Oh, we had a UFC fighter come on.
Yeah. But, I mean, the NFL Man of the Year award is the Peyton Award.
Yes. And I remember I was 18 years old, downtown Chicago in a sports store. And I'm in an elevator and I look at this guy and it's Walter Payton. I could not believe it. And he was just like the nicest, most down-to-earth guy. And he just wanted to tell me, like, okay, well, what are you studying? Stay in school. Make sure you focus on your grades.
That's right. That's what I tell my 14-year-old. Go to school. She wants to be a Marine.
Oh, good for her.
And I'm like, going as an officer.
Yeah. There you go.
But anyways, so Jim always favored the Missouri plan.
Mm-hmm.
So Jim, you go ahead first.
Okay, yeah, and I think, Judge, we were talking a little bit about it before, and Steve and I, well, first off, I give Steve a lot of credit for this. I'll be perfectly honest, I was the average voter before I met Steve. I was a down ticket voter. I voted all R's, and judges, I went, okay, cool sounding name.
Cool sounding name.
Heard of them. Literally. So then Steve calls me up, he goes, you don't have to tell me who you voted for, but just kind of curious who you did. I told him one of the people I voted for. He says, okay, why? I said, well, they're a Republican. He goes, do you know anything about them? I said, no, I know they're a Republican. He goes, okay, well, that makes you as ignorant as they could be. And then he said, judges impact your life immediately, so they're very important. And then as I started learning more about the judiciary, I said, this electing judges, I don't like it. And and I can't remember her name, but Elizabeth was her name?
Was it Halverson?
Halverson, yeah.
Oh, yeah.
You know, that was kind of the final straw for me on judges getting elected. Not to be mean, but honestly, so I started asking in every interview. I would ask every judge, what system do you think is best? Electing judges or appointing? Almost every judge, except for one, told me, well, state law is we elect judges, and kind of dodged the question. Except for Judge Assad, he goes, appointment. So I started looking at all these different plans. I came across the Missouri plan, and I said, that kind of makes sense. So you originally have to go through the appointment process, and then you go through a re-election process. So I think it's pretty good. You guys can correct me if I'm wrong. I did some research last night when I was pulling up stuff on the Missouri plan. I guess I was misled because I thought it was all judges in the state of Missouri were appointed and then elected for retention. But I was reading something that said it's only for the Missouri State Supreme Court and Appellate Court that's true. And then the rest of the judges are elected. Is that correct?
And I didn't look at it from that perspective, but what you find that a lot of states have a blended plan. For example, in Utah, the state court judges, meaning district court judges or the judges from general jurisdictions, they are also under that plan. And just to make sure, I guess, the viewers that are watching that might have some interest in this issue, I think it's important for them to understand what the Missouri plan really is about. And so what happens is essentially this: if you have a judicial vacancy, you have to go through a vetting process. That's the appointment process. And then, and sometimes 20 people apply, 50 people or whatever. But then once you're appointed by the governor ultimately, and they have a process very similar to us, because here in Nevada, what happens, they have a committee that's headed by the Supreme Court. And then we have members of the public, members of the bar, and they participate in that process, and they'll push 3 names to the governor.
Do you know what they look for?
I'm not 100%. I mean, I've never watched it.
What would you look for?
I'd look for experience. I mean, at the end of the day, I'd look at the credentials would be of paramount significance to me. I mean, that's it.
Yeah.
Nothing else really matters. I'd want to know, have you had an opportunity to try cases? And that's not the end all. Have you done appellate work? Mm-hmm. How many cases have you filed? Have you been vested in the bar? And what I mean by that is there's a lot of committees for the state bar. Have you participated in that? Have you held leadership positions with organizations in the bar, right? And
reputation and temperament.
Reputation and temperament. And for example, I know people don't know this per se, but lawyers are rated. I don't know if you knew that or not. Lawyers are rated based upon ability and ethics.
Who rates them?
Martindale Hubbell. They've been doing it for 100 years, right? And that's part of it too, right? And the thing about their rating system, that's done anonymously. They send out letters to the members of the bar and the bench, and they said, "Okay, what do you think about this lawyer?" And they have an A, B, or C rating, and that's part of the process too. And so, and I don't mind saying I was A rated, as a practitioner, AV rated. And that's all important. So, and the types of cases you did. Have you done anything of significance in the law? And that's really what it comes down to. And you're 100% right. Temperament's a big deal. It really and truly is, because here's what I think happens, and there's no question, especially now, we're so politically polarized, right? Mm-hmm. But judges don't make political decisions, right?
They should.
You go into family court. I mean, the issue is child support and child custody and divorce, right? And dividing up the assets. But like, I'll give you an example. I had a case I can talk about a little bit. I had the Wynn shareholder derivative litigation case, right? And that case involves Steve Wynn and the board and whether he should be removed and all those things for the benefit of the Wynn Hotel and Casino, right? What does that have to do with politics, right?
Nothing.
I had another case involved, and this is a really important case. It was a class action construction defect case in Clark County that involved allegations of defective plumbing that impacted 20,000 homes in Las Vegas, right? What did that have to do with politics? Nothing.
No. Well, just real quick, I did want to add something on that and tell me if this is what my experience has been. And when we've went through panels and stuff, and this was like 2012, we had someone on the panel, and luckily they were sitting next to me, so I kind of talked to them about it. But we had, it was Justice of the Peace District, I believe it was 13. And the first question he asked is, so when you're writing your opinion after you've made your decision, how do you think you should phrase it? And I turned and looked at him and I said, a JP doesn't write an opinion. So I think what I'm trying to get at is I think a lot of people just assume that every judge is like the Supreme Court or the appellate court and actually writes opinions. So you always want to hear, do you legislate from the bench? What's your stance on Roe v. Wade before it got overturned? And it's like, wait a minute.
That has nothing to do with what we do. You're 100% right.
So I think that's part of the problem too, is like everybody is not running to be a Supreme Court judge or an appellate. Right.
And you're so right, because each one of us, depending on what type of caseload you have or the jurisdiction of the court, is vastly different. For example, I mean, what I do is nothing like what they do in municipal court, right? Very important function, but our cases are just different. They just are. And that's a really important point. Occasionally, I have to issue decisions that I will write out. Right. And the reason why I do that is this: I want to make sure my record's clear. So when somebody reviews the record,
watch the mic when you go like
Oh, thank you. Okay. Yeah, but I want to make sure when the record's reviewed that, everyone understands it, right? And because you can put it in writing and, you can read it and you can say, okay, this is what the judge was considering. And that's,
Right.
Yeah, but you don't have to do that in justice court.
Right. That's exactly what I'm saying. That's why I like the Missouri plan a little better, because you're looking at individuals that really truly understand the law, or hopefully do. I mean, I know a lot of people who vote, and I'm not trying to be rude to the voters, but it's one of the reasons why we do this show is to inform people. They're like, literally, I'll ask them the most basic constitutional question. They do not have a clue. And that person is going to be responsible to elect a judge. That seems a little terrifying to me.
Well, what percentage of the population do you think really understands or does any in-depth study about each person who's running for judge?
Out of the people,
Just based on your circle of friends.
I'd say about 8.5% probably.
If that much.
Yeah, that's high.
Because in my experience, and I speak as an attorney, I have relatives, I have friends who come to me and say, I have no clue who any of these people are.
Fill out my ballot.
Can you fill out my ballot or help me fill it out?
do that all the time.
I don't want to say fill out my ballot because I'll be admitting to in front of a judge here. So
They ask me, I tell them.
But the point is, people, a lot of people, I think, they don't even want to be involved in that process, but they don't also not want to vote and throw away their vote. So they make decisions based on the most superficial basis.
Right.
And I think what the judge said is correct. There is no such thing as a perfect system.
No, there isn't.
But if you have a system where you have to fill out a 15-page application, for me, as an average citizen, I would like someone who's going to become a judge to go through that rigorous process like Judge Williams went through. And don't you think we should want to know, like, if someone has paid their taxes or not? If you can pay a filing fee under our current system and you've been a licensed attorney here in this state, you can run for judge. And that just doesn't make sense to me.
And here's a really good point. I mean, everything you're talking about is true. People have run for judges that had disciplinary complaints pending before the state bar.
Yeah.
And what's important about that is this: you would never apply for a position, seeking an appointment because
you wouldn't need to be taking
and the public doesn't know. And I think what we have to come back to is essentially this: what is the Missouri plan? You go through an appointment process, which is rigorous, and ultimately the governor appoints you as a judge. Then 6 years later, you come up for retention. Yeah. And that's one thing that's overlooked because the public still gets a voice in that.
Right.
But when you talk about the Missouri plan, are you just talking about for district court, appellate, supreme? Or are you also talking about muni and justice of the peace? Because they don't go before the governor, it would go before the council or the county commission.
And you know what? That's such an important point.
Missouri plan for the entire judicial system or just district court on up?
Understand this. I'm not advocating for either way. I think people need to know what's going on. And I think you brought up an important point, how it's different in some states, because I think it comes down to where you fit. Are you a municipal court judge and you come under the city, right? You're a JP, you come under the county. And we happen to be district court judges, so we're state judges. Right. And so I guess hypothetically, if there was a constitutional amendment, it would be district court, court of appeals, and Supreme Court. But what's important about that is this, and this is another factor that they use in the Missouri plan. When you come up for election 6 years later, you have what's called a retention election with no opponent, right? But that's not the end of the story because the public says yes or no, so they still get some sort of input. But what happens during that 6 year time period, you're on the bench, they have a commission that comes back and reviews your work. How's your temperament? Right. Do you start court daily? How are your decisions? And the thing about it is all decisions, when it comes to discretionary, you can do the right thing and someone else might think, well, I should have done it differently, right? So that's not a big deal.
It all depends on, if you rule on my case and I like your ruling, you're the best judge ever.
That's true.
So you saying that there's a watchdog that watches judges in the Missouri plan?
Oh, absolutely. Absolutely.
That is not in effect when you elect?
What's in effect when you elect? Nothing, right? Other than who can raise the most money.
The Judicial Discipline Commission, which doesn't even do a doggone thing.
Well, that's another committee there. But remember, we're not talking about judicial discipline. We're talking about elections. But see, here's my point. For example, when it comes to the committee that reviews the body of work that judge might have had for 6 years before he comes up for retention, they can make a recommendation. Yeah, he's done a good job or she's done a good job. We say they should go forward and, we are in favor. Or they can say, look, you know what? They've been late. They got terrible temperament. They're throwing stuff up on the walls and we don't, and we've had that, right? But but it's true. But
No, just Steve and I think we know what you're talking about.
But it's true though. But they can look at that and say, look, I don't think this person has maybe the temperament to be on the bench. Right. And here's the thing: you have to understand the commission. As far as that's concerned, it's appointed. You could potentially be on that commission. You could be on that commission or someone, but they look at it. I don't know how.
I did put my application about it.
Oh, did you? Yeah. But this would be the commission to even review under a Missouri plan.
Mr. Padda, could you explain the difference between the electoral process and the Missouri plan and the pros and cons in both?
Well, my understanding of the Missouri plan, and going back to a point the judge made, I believe under the Nevada or Missouri Constitution, they give local counties the decision-making authority to decide whether they want to have appointed or elected judges. So I think St. Louis County, which is the largest county in Missouri, actually has the appointment process. So that's my understanding of how the Missouri plan works. And then, like the judge said, there's a retention, election. So the voters still have a say, and they have a record to look at. And I believe the retention election takes place 1 year after the appointment. So it's pretty quick. So basically now voters have the opportunity to look at someone's record for a year and see whether they're doing a good job or not. Now, under our current system here in Nevada, if you don't draw an opponent as a judge, you're on there for another 6 years. Mm-hmm. And I think that what we have
unless
in Missouri,
we have remove and retain, but that's
I know you've advocated that before, and that's kind of like the Missouri plan in terms of there should be some type of referendum or election to say, okay, this person is doing a good job or not.
And you know what? And you hit it on a really important point, in my opinion, because at the end of the day, under Missouri plan system, you have someone, kind of like a watchdog, saying, look, is a judge starting court on time? Is he there every day? Mm-hmm. Is he issuing his decisions timely, right? Or is she having an issue? But at the end of and then they make a recommendation. So potentially, when it comes to retain or not, the public would have a source of information they can go to make that decision.
The one counter argument that I have heard for the judges that would eventually have to be appointed by the governor, and this was from an attorney friend of mine I was talking to, this was a couple years ago. He said the reason why he didn't like that plan is because, for instance, like he was saying, what about if the governor isn't an attorney? Like, why should the governor be someone to appoint a judge? I mean, what makes the governor know more about if the governor, in other words, if the governor is not a lawyer, then what makes him qualified to appoint?
It's a good question. I'll let Paul answer it first. I'll jump in.
Well, like we said, there's no such thing as a perfect system.
Right.
But under our current system in Nevada, if there is a vacancy to be filled, the governor doesn't just pick someone's name out of a hat. Right. There are people who apply for that position. Right. And then that field gets winnowed down to 3 people. Yeah. And the judge and the governor can look at their credentials, evaluate, get input from other people. And I don't think lawyers should be the only ones making the decision as to who's a good judge. I think it's like you said early on, if you're an average person, your interaction with the system or society, you're going to be more affected by what judges do on the bench than you are necessarily by a United States senator. So I like the idea of someone who is not necessarily a lawyer playing a role. I don't think there's anything wrong with a governor making the appointment, just like the president, in the federal system, United States senator can make a recommendation. That person has to clear a legislative committee. Then those names get sent to the president. And I think that it's a collaborative process. And right now, with having applications, I think, like the judge said, I would like to know if someone hasn't paid their taxes. I mean, you are so scrutinized, and it's ironic that it's harder to make it to the bench as through an appointment than it is to pay, I don't know what the filing fee is,
$150.
$150, and you don't know anything about my background, whether I was suspended, disbarred, maybe I've been sanctioned 50 times, maybe I've cheated my clients, and now all of a sudden I'm a judge.
Maybe he doesn't pay his child support.
Yeah,
All those
right.
things come into play, right?
Well, my counter argument to it was, I was like, okay, if he is the chief executive officer of a state, he should have some understanding of the legal system.
100% right.
Right? I mean, that was my counter argument.
Well, no.
Or at least I would sure hope so.
Yeah. But you have to remember this too. The judge has staff that'll make recommendations. Many times those are lawyers. But just as important too, and this is one thing good about the Nevada current system when it comes to appointments, the governor is not in charge of the final 3 names. That's done by the judiciary. And so the screening process is headed up by not just a lawyer, but the Supreme Court for the Nevada Supreme Court Chief Justice does that. And then they have another bar member on that committee too. And they are part of the review process, and they scrutinize those applications. And just as important too, under our current system when it comes to appointment process, they have members from the public, they have lay people, they have a couple appointments from the governor. And so you get kind of a mixed blend of citizens. And they get a chance to ask a lot of questions. And in a general sense, I think this is probably true. And I haven't looked at it statistically, but it appears to me that from an appointment process perspective, there's not many judges that have hit the bench with baggage or problems.
You know, the Judicial Selection Committee is trying to get rid of, it looks like, the part that's open to the public, because they used to have it. I remember when I was going to a lot of these Judicial Selection Committee meetings, they used to have open to the public every single day just before the interview process starts for that day. Now, the recent one that's coming up in February, they only have one day open to the public, and then that's it.
I don't think that's right. I think there should be complete transparency.
That's it. Done deal. But you could send letters in and stuff of that nature. But you can't go there and physically speak.
Which is something we need to look at.
If I'm gonna jump on, let's say I was one of these legislators and could make that decision. If I'm gonna jump on this Missouri plan thing, then it should be all open to the public every single day they have an interview. That day, whatever, 15 minutes should be open to the public so the public could come in and speak their mind about an applicant.
Yeah. Because for my position, and Steve, I'm not going to put words in your mouth, but I'm pretty sure knowing you'd agree with me on this. Most, not all, but most people that are willing to go to those meetings, they're vested in that process. They care about the process. You see what I mean? Rather than just going on a ballot and saying, oh, this is a cool name or whatever. They really are truly, they got some, like I said, they're vested in the process. So I think you get a better pool of people as far as understanding the law.
And plus they have additional information about the applicants that is not on paper. I mean, some of them might have personal experience with that particular applicant. Some of them might have professional experience with that particular applicant. If you're not going to give the public a chance to speak, this is one of the reasons why I was against the Missouri plan, because I think that, the people should be able to vote for their particular, whoever's sitting on the bench. But if we're going to go to the Missouri plan, they have to have a portion every single day of the interview that is open to the public, that the public could come in and voice their opinion, whether you might like it or not. But the public has to have an input. And I'm so adamant about public input.
Well, I agree with you for a slightly different reason. I mean, I agree with everything you just said, but just as important too, and we can't overlook, transparency.
Yeah, true.
Right?
And that's part of transparency.
That's part of transparency. And I will say this, when I was appointed in 2006, the selection committee process was not open to the public. Then later they opened it up, which I thought was a great thing. And you know what? You have to have transparency if you want a public to have some faith in the processes, right? So, and potentially they should, I'll go a step further. Maybe on public TV, they should televise the interview process.
Yeah. I agree.
Because
just like they do with city council meetings and county commission meetings.
And here's why it's so important, because, we have to have faith in our judicial processes, right? We do. And the first step would be transparency. It's like, for example, I don't mind saying this in court. Now we have blue jeans, and a lot of our cases are heard that way. And I get from time to time media requests, and I say to myself, they got a right to be here. It's a public courtroom. And it really is, Yeah. And so I could care less, if they want to do it by whatever means.
Some judges are intimidated by the cameras.
Yeah, I'm not. In fact, I like to play up there.
My thing is, if you're a judge and you're intimidated by the cameras, then you should be on the bench.
Right.
Well, you run a campaign. If you're afraid of the camera,
Well, and part of it is this open, because we have rules. I don't mind saying this. We have rules in place, and occasionally I'll get a media request, and it's not within the appropriate time period. I just sign them. Yeah. And I remember one time. This is interesting. I had a case. And it was really high profile, right? They were having press conferences right out of my courtroom every day during trial. And we had the French Free Press in there full time following this case, And I looked at it from this perspective. You know what? We're a public courtroom. It's a court of law. And the courtroom belongs to the men and women of Clark County. And there should be open access.
Was that the Binion case?
No, that wasn't Binion.
Oh.
No, this was actually the Dr. Desai and the case,
hepatitis case.
The hepatitis C case. Yeah.
Okay. So the way it works, Mr. Padda, is that with the Missouri plan, is that the Judicial Selection Committee sends 3 names to the governor. Governor picks one, and that person goes for retention. So what happens when that person goes for retention? And the voting public says, no, we don't want that person. You did it wrong.
Then they're out. That's my understanding. Yeah.
So the process starts all over again.
Yeah.
Oh, yeah.
Okay.
And see, here's kind of the point. I mean, the public still can make a decision, but I think under that process, and you know what, I don't mind saying this, but there's so many different ways we got judges. I mean, look at the federal system. We appoint judges for life. Should that really happen? I mean, you see what I mean?
I don't think it should be for life.
Yeah, and it's maybe 20 years, something like that. But
no, I think that's a little bit too much.
Okay, I understand. But I get what you're saying. I do. But what's nice...
Because time changes.
Yes, it does. It does.
Laws changes as well.
It does.
And sometimes some judges are not caught up with the change of the law that the judiciary did.
Steve, I will not disagree with you. You make a lot of sense. But here's the point. Say hypothetically we had a pure Missouri plan in Nevada, right? And so judge gets appointed the first term, not a lot of problems. The committee says retain him, and the voters say, okay, we'll follow the committee's recommendation. He gets in or she gets in, and they're like year 7 or 8. And for whatever reason, they start having problems, right? Maybe they're not showing up on time, or maybe not issuing their decisions timely, or whatever. And the commission looks at their body of work and says, you know what? I don't think we should have this person retained, and they issue their report or recommendations. Then under those circumstances, at least the public will have an informed way to make a decision and say, you know what, this person has been reviewed, and we've looked at their past history as a trial judge, and we don't think they're fit.
Well, right? And one of the reasons why I'm glad we're having this discussion too is because, like you guys both have said, and there's no perfect system.
There isn't.
But one of the things that I think particularly makes this country unique and makes it what it is because you do have 50 states. Yeah. And each state has their own constitution. So we're like our own little incubators of democracy, each state. So like we'll just, for sake of argument, let's legalization of marijuana. Okay, Colorado legalizes it, but they're having some problems with it. So now when Nevada goes to legalize it, they tweak because they know the problems. They see the problems that Colorado's having, so they tweak those. So what I'm saying is if we start a conversation like maybe a pure Missouri plan is not perfectly ideal or maybe the best full plan for the state of Nevada, but we need to start looking at it to where we can maybe develop our own form of the Missouri plan. Now, I know that's going to be difficult because it's going to take a constitutional amendment. Obviously.
Absolutely.
And the tough part about the Nevada state constitution is it's pretty unique compared to most states.
It is.
So it's pretty complex.
It's because we have to vote on it twice, right?
Yeah.
To change. So and for the Missouri plan to take effect, that it has to go before the voters 2 different election
Two
years.
different cycles, yeah. It would.
Right, just like the one that we got no primary, and now it has to go again.
Yeah.
It passed this last session here, but if we don't have the Missouri plan in place, what could we do right now? And one of the things that Veterans in Politics came up with in the last legislative session was to remove or retain a judge. And like Paul was talking about, if a judge is on the bench and nobody is opposing this judge, then the judge is automatically in for another 6 years. And we're talking about the district court seat. So in the last session, we came up with the remove or retain, and the way it works is similar to the Missouri plan. If an incumbent,
Yeah, you're coming there. You're coming along.
yeah, if an incumbent is in the general election under that name, you have remove or retain, and if remove gets more votes than retain,
Right.
the seat's vacated. Judicial Selection Committee takes applications, sends 3 names to the governor. Governor picks one and fills that vacancy, and then that person goes up for retention.
Now, but doesn't
the
that
following
also
year.
require a constitutional amendment?
Probably.
You know,
Probably.
I don't know if it requires a constitutional amendment. I know it was in committee last session, and the committee leader killed it. So Brittany Miller killed it.
Yeah, she killed it.
I call out names.
I have another really important point for everyone to remember and not overlook. What does the Missouri plan do from a judicial perspective in reelections? If you're under a Missouri type plan with a retention election only, judges can't raise money. Think about that for a second. So all of a sudden, money is taken completely out of the equation, whereas today, under our current processes, judges raise money. And don't you think it would be a better system, potentially, not to have judges raising money, right? And here's my point. They can't raise money under the Missouri plan. They can't campaign, right? And so hypothetically, if there's a problem with them, they get the thumbs down, right? They can't go out and raise a lot of money to convince the public to go ahead and reelect them. No, they have to live with that decision by the commission that says, look, don't retain this judge. And then you have outside sources, for example. If Veteran in Politics agrees that this judge shouldn't be retained, then they can campaign that judge shouldn't be retained. And actually, to me, that gives the grassroots organizations more power.
Yeah,
Potentially.
it's true.
See what I mean? You didn't even think of that one, did you, Steve?
He's trying to put me on the spot.
But we've got to take money. That's part of it, taking money out of the process.
California has a law. Okay, if you raise $1,500 or more, then that judge has to put on record to both parties that they have raised X amount of dollars from this particular law firm, right?
Right.
And it's up to the parties to say whether the judge should recuse her or himself or not.
Right.
Well, the problem is that you can game that. If you're an attorney, you can donate to $1,500 to every judge and just get them off the case, and now you have no one presiding over your case. So it's not that doesn't sound to me like a perfect system either.
I agree with Paul. I really feel this strongly about this. It would be nice just to get it out completely.
Yeah.
Right? And
Do you think there should be a law here that does that though, or no?
A law to do what?
To for a judge to say, hey, XYZ law firm gave to my campaign. Do you guys still want me to continue with this
Well, I think
case?
usually
or
that's a
should I
matter of
recuse?
public record. You can go and check their CES, disclosures.
But you don't think a judge should automatically
have an affirmative duty?
Yes,
Yeah.
say that.
I don't know if it makes a difference one way or the other. I mean, as far as allowing the parties to decide whether the judge should then be on the case or not, I think that's problematic. But as far as a disclosure requirement, I don't have an issue with that. I don't think there's anything wrong with making a judge do that. But I do think the idea that the parties could just challenge a judge based upon a financial contribution and say, well, my opponent gave something to this judge and therefore they should be off the case. That doesn't make a lot of sense to me.
interesting. And
How do you feel about that?
I think if they're going to do something like that, this is the only problem I see with that, is this. And if you've ever been to district court, it would be tough to keep track of who's given to you and who hasn't, right? And so if they want to do that, maybe they should have something published outside the courtroom, right? Right? I mean, I believe in transparency.
Okay.
That's probably a better way to handle it, to put that burden on the judge, because we have pretty tough jobs sometimes, and you're not in that zone. You want the judge to be in the zone of what are the facts, what's the law, and you want the judge to make the right decision. And I think if they wanted to do that, I'm fine with it, but have it published.
Since I have you two legal minds here, I have a couple other questions in addition to the Missouri plan,
Right.
or remove or retain. How about term limits on judges? Do you think that they get too comfortable after a while, and maybe we need to say 8 years is enough? Judge,
I can tell you this. I mean, no, I don't have any problem with term limits per se, but for example,
or 12 years should be enough, right? 2 terms.
I think it's probably, this is how judges evolve, right? Especially and Paul can tell you this, especially in cases involving complex litigation, right? Okay. So the judge hits the bench, and and he might come out of a specific area of practice, right? Okay. But in district court, for example, one day I can have a class action case. The next day I could have a shareholder derivative case. The next day I could have a medical malpractice case. Next day I can have a complex products liability case. But here's my point. Judges, they come in, and most that go through the appointment process, they have a real good idea of their area of specialty that they practiced, and they have a good knowledge of, for example, civil procedure and trial procedure, right? Mm-hmm. But when I hit the bench, I wasn't a class action lawyer, right? However, by the time I was done with Ed Ray Kitech, I knew class action litigation backwards and forwards. And here's my point.
Maybe more than you even wanted to.
Oh, more than I ever wanted to. I mean, it's the same thing as shareholder derivative litigation cases. I know all about that. I know about the origin and all that. But my point is this. I think it's like Jordan in his prime, right? And Jordan in his prime stepped away for a year and a half, right? And he shouldn't have. And so so I think judges have their prime. And I feel very strongly about this. If there's going to be a limit, I think 20 years.
20 years.
Yeah. And here's why. That judge hits his prime probably about year 6, where they start seeing a lot and they become really learned, seasoned, right? And so you don't want to get rid of them 2 years later. Right? You agree with that?
I totally agree with that. I used to actually have to take hold of view that term limits could be a good thing. Right. And not really, I wasn't thinking about judges. I was thinking more at the national congressional level. And I know actually there's a bill, I think, that they're trying to pass to put term limits on Congress people. But I have changed my view on that. And I think what the judge said earlier is, to me, the key issue is the problem is not term limits. The problem is the money. And where I come down on this is that for me as a lawyer going to court and representing people who are dealing with difficult situations and circumstances, I want a judge with experience. Why would we want to get rid of someone like Judge Williams, who has this now institutional experience? He's seen, hundreds, if not thousands of cases, trials, and you become better and you start to see different angles and permutations on cases. So the judge that he is today is not the judge he was when he first took the bench. Sure. Why would we as a community want to deprive ourselves of that?
He was a lot younger.
He was a lot younger. Right. But the point is, that's the problem with term limits as I see it, is that, to me, it's more harmful. I want highly experienced judges who are there and they're doing a good job. And that's the whole point of the retention system. You still, you have that check and balance to be able to say, okay, if this judge is, maybe they don't.
He's a little long in the tooth now.
They're not as sharp as they used to be. Well, then the public can step in and take that position. There you go. That sort of thing.
Right.
But I don't want to be. And I heard someone say to me recently, "Well, it's your job as an attorney to educate the judge." That's somewhat true when you file a brief. But I would like the judge to be educated already about certain things that I don't think I should explain to them.
How many judges would appreciate that?
He's 100% right. The only, I look at it from this perspective, I don't mind saying it because I've been on the bench so long now. when I can tell you this, if a lawyer is going to educate me in a general sense, he's going to educate me on the facts of his case,
Right.
and the application.
Not
to
the law necessarily.
not the law, and we can have unique issues in the law, but at the end of the day, I'm more concerned about the facts and the law. And I don't mind saying this, for example, in district court, that's where all the heavy lifting occurs.
Yeah.
It really does on a day-to-day basis, Paul. You know how it is because you've been on our calendars.
Right.
It's like from this to that, all these different issues. And maybe, but Massachusetts has term limits based upon age. 70 years you retire.
Oh, really?
That's what they do. Yeah.
Okay.
All
right. Let's move it along.
That's a great question.
Let's move it along, Judge. Let's talk about qualified immunity.
Okay.
What do you think about that? You think that I've read somewhere saying that qualified immunity was being removed. Is that a true statement?
I believe there was a recent Supreme Court decision on that, here in Nevada on that issue.
How do you feel about the removal of qualified immunity when it comes to the judicial bench?
Well, I don't think, does it apply to the judicial bench? Because at the end of the day, I'm trying to figure out what would be the basis for the qualified immunity. I mean, I get it for like police officers, law enforcement, and those types of things. But for example, if I make the wrong decision, in a general sense, the only thing you can do is appeal. Mm-hmm. Right? Yeah. And so that's kind of how it is. But I'm trying to figure out how would it apply to judges. I don't understand that really.
I don't know that it does apply. I think that, I haven't studied that decision yet. I'm going to read it, but I think it's very narrow. I don't know that it extends to judges, and it's very well settled in every state in this country and the federal level.
In their judicial capacity.
Yeah, in their judicial capacity. Now, if you have a job, as the judge does, where you have to make a ruling and 50% of the time you're going to disappoint people, the other 50% of the time maybe you'll make them happy. Sometimes you might make a ruling that makes both sides unhappy. You don't want a system, no matter, and that's an issue of passion, right? We can all say, hey, this judge made a bad ruling, but we don't want to encourage a system where a judge has to be worried every time they make a decision, they're going to get a lawsuit. That would be a crazy system.
Let me just change it, and let's say that a judge deliberately violate constitutional rights. Do you think that judge should be
That's a problem.
Independently sued based on that in federal court?
I will say this, it might come down to the facts.
Okay.
If you understand what I mean. As far as in the judicial capacity, making decisions, no. But say hypothetically the judge is doing something that might breach the canons of ethics, that might be a problem,
And that's why we have courts of appeals and the Supreme Court.
Right.
They can step in and say, hey, maybe this judge shouldn't be on this case based upon, evidence of some type of bias or something like that. I think that, and I know there was a decision in March of 2022 that made it actually harder to challenge a judge for bias. And I think there was 3 judges who dissented from that, which are now in the majority, who said, and I think it was Judge Kadish who said that this is a decision that will invite cynicism. We should not be making it harder to challenge a judge for bias. We have a supervisory duty to take a look and see if this was a valid point. And I do agree with that. But I don't think it's a good system where judges should be worried about getting sued for making a legal ruling. Who are you going to encourage to be on the bench then? You're going to get rid of good people, You don't want that. I think it is public service. Being a judge, Judge Williams was a successful attorney before he took the bench. You give up a lot of money to do that. I want highly qualified, smart people on the bench who view this as public service, and
are humble.
That are humble, and they're doing it for a different reason. They're doing it because it is kind of an academic job. You read a lot and you make decisions that affect people's lives, and you want someone who's thoughtful. And I've had judges make rulings that I did not agree with, but I completely respected the judge because I knew that person came to the situation doing the best job they could with the facts, and you are going to make rulings. And so my job is to be an advocate, right? And so, of course, sometimes I'm going to try to push the envelope, and I respect judges who say, well, the law does not allow you to go that far, and that's good. I want people like that on the bench. So I think it would be a terrible system to remove any type of immunity for judges, as far as now making them worry about being sued.
And who would potentially benefit from that? Hypothetically, because the little guy can't afford to hire lawyers.
Right. That's right.
Right. Maybe a big business or some corporation, national corporation, is upset with the decision, and they might say, well, we're going to go ahead and sue the judge. In contrast, the citizens in family court, they can't afford that. You see where I'm going on that? That's part of it too.
But some attorneys would probably take a case like that pro bono.
Maybe, but at the end of maybe I don't know.
What could we do to make the bench a lot more stable and a lot more transparent than what it is today? Could we get rid of discretion?
No, discretion is important. We have to.
Why is discretion important?
Well, it is so important because understand this: the law is not necessarily just black and white. There's so many shades of gray. For example, if you read the rules of civil procedure, the judges are given broad discretion on certain issues. However, their discretion can be tempered. For example, if a lawyer misses a deadline, right? And under Rule 37B1, if they have substantial justification for that or it's harmless, then the judge can look at that and exercise their discretion and say, well, the trial's not for 6 months. It's really harmless, right? Because at the end of the day, this is what you want. We can't overlook why we're here, right? Judges. And we're here for justice and fairness to the parties. And these rules and statutes many times aren't self-executing. Some are, but most aren't. And so you want to judge it because all I want is this: if cases don't settle, I want lawyers to be able to walk into court and try their case and say, I had a fair day. And the judge treated me with respect. His temperament was good. He made tough decisions. And then it was in the hands of the jury. And the jury decides. That's our system.
And sometimes the judge has to look beyond the lawyer. Maybe the lawyer did do something that they shouldn't have. They missed a deadline or something. But then you got to take the bigger picture and say, well, what about the client? This is a significant case. This person has come to court. So I agree with the judge. You have to have some discretion in the system.
Do you think it's important for a judge to, at the end of their decision, to explain their decision to both parties so they can have a good understanding of what's going on and why you came to that decision?
Absolutely. I'll take it another step. And I do this. Paul would tell you this. I'll sit in court and I'll tell you why I think I'm going this way, or I might see something a certain way. And then I'll invite you and I'll say, okay, this is what I think. Tell me, why am I wrong?
Yeah.
Right?
I've heard that speech before. It's good.
Yeah.
It's a conversation.
Am I missing something here?
Yeah.
Point something out to me, because I have no problem with that. I don't look at it as an ego in this respect regarding the lawyers. Because I look at lawyers, they're there to teach me about the facts in the case and sometimes the law. Because one thing about district court, the law is so broad. It really is. I mean, we have volumes and you have a whole law library on the law, And so I sit and listen to lawyers, but I do feel very strongly that when I render a decision, if I can't explain to you why, I need to go back and do a little bit more research. I feel that's how I live my day-to-day practice as a judge.
And how long before, if you take a case under advisement, how long before you render a decision back?
Well, the
to
rule
parties?
says 60 days. 60 days. Right. And I try to get it done.
Some judges go beyond that.
Oh, yeah. Yeah.
We've heard horror stories about 6 months.
Yeah, what do you do to those judges that do that?
Well, that's up to powers other than me.
Paul Potter, what would you do to those judges that did that?
I don't know that there is much you can do. I mean, you have to keep in mind the bigger picture. You're there to advocate for a client and do right by that client. So you don't want to inflame or irritate that judge. It is frustrating, and you explain to your client, hey, listen, we have to focus on the bigger picture here and not get caught up in this little battle. But in defense of the judges, I think they have a lot of cases, and so there's just a lot going on at the state court level. With the amount of
60 days is not sufficient?
It's sufficient.
It's sufficient. Yeah.
Yeah, it is.
At least a judge can announce.
And that's business days or that's calendar days?
I think it's calendar days. Yeah. Right? I think it's calendar days. And and here's the point too, and this is what I always, I don't want to just say motion granted, motion denied. That's easy, right?
Yeah.
I will issue minute orders that might be 2, 3, 4, 5, 10, 15 pages. if it's a very complex case. And the reason for it, I do it for two reasons. Number one, I feel it's important for me, from my perspective, to explain to the lawyers why I'm ruling this way.
Yeah.
And there's another benefit to that too, because that becomes part of the record. And so the Supreme Court or Court of Appeals can look at my analysis and say whether I agree or disagree with the judge, you know. But it's important because I just feel you have to be able to explain your decision. You just do, you know, and I don't mind doing that.
One
Paul,
thing about
tell.
you, Judge, I do like is, you know, the term argument gets used a lot. Well, my experience with Judge Williams in his courtroom, it's not argument as much as conversation. And he does come out and say, I've read everything. Here's what I'm thinking. He'll invite a conversation, which is good because I've been in courtrooms where the judge will allow each attorney to talk. And sometimes the attorney will drone on for 30 minutes and then the judge will rule on something completely unrelated to what this person has just said. That to me is often a sign of an inexperienced judge. But Judge Williams will get right to the issue. Here's why I'm going to rule this way potentially. You can try to convince me otherwise. Maybe I'm not reading the right, you know, I'm interpreting the law or make it.
Use that reverse psychology. Huh?
Yeah, but that's good. I think that's really, and I think from a client's perspective who's sitting there, that is very much how the process should work.
And you want to know why I look at it that way? Because you have to understand this, and this is why the appointment process is very important. I remember my first month or two on the bench, we had the old Blackstone system, right? And under that system, you could just do a name search and determine how many cases a lawyer has litigated in the 8th Judicial District Court. And I mean, I don't know how many cases I litigated in total, but my first law clerk told me, she said, Judge, we know one fact, you've litigated more than 1,000 cases in this jurisdiction. And so from my perspective, if I'd been in court 1,000 times arguing cases and the like, I just wanted to be the type of judge that I wanted to appear in front of. Yeah. Right? That's it. That's nothing more, nothing less. I want to, you know, and just as important, I'm not here to be adversarial with the bar. I'm not, because you know this, Paul, and this is a fact. I'm probably one of the easiest judges when lawyers agree.
Yeah, that's right.
If lawyers agree, right, I let them do what they have to do, right? Yeah. I'm not here to be an impediment to the ultimate resolution of this case, right? Yeah. Right. And this is kind of how I look at it, right? This is the easiest way to say it. It's like Justice Balls and Strikes. That was Chief Justice of the U.S. Supreme Court.
Oh, Roberts.
Oh, yeah, Justice Roberts. Justice Roberts says, I'm here to call balls and strikes. Right? He's right. But there's more to it than that.
Yeah. Right.
What if there's no pitch? Yeah. Why do I have to make a call? What if you guys, you have one client, you have the other. He says, Judge, you know what? We're trying to work this out. We don't want to go to trial in 30 days. We think we can get this resolved. Why should the trial judge sit there and say, no, you're going to trial? When only 1/2 of the cases go to trial anyway.
And not only that, what about all the money that's involved?
There you go.
I mean, now you got to, you know, that's to me, I don't think a lot of judges often appreciate how much that Judge Williams does. But I know that, you know, some judges who've gotten on the bench through an election process, yet again, another reason for the Missouri plan, who may not fully appreciate what it takes to take a case to trial, how much that costs. And just not for both sides, defense and plaintiffs.
It doesn't matter.
Yeah, and so usually what the parties want is they just want resolution, and
absolutely,
that's ultimately that's what this whole process is about. It's about solving disputes, right?
I want to talk a little bit about tardiness, and if I'm paying $450 for my attorney, and the court case starts at 9 a.m. and now it's 10:15 and the judge still hasn't taken the bench, should I still be paying my attorney, or should somebody else pay for my attorney?
45 minutes.
All I can say, Steve, I don't mind telling you this.
Who should be paying for my attorney?
You know, I will tell you this, and I understand the frustration. I'll give you an example of something I do different than most judges, right? Because I get that. My calendar is set up day-to-day in law and motion calendar. I have the unopposed motions and status checks first. Then we have the contested motions, right? And Paul will tell you, if he's on an uncontested matter that they need something from me or both sides agree, they're out of there with 15, 20 minutes. They're not staying there till 11 o'clock because I call them first. And then we take the cases that are contested that involve argument in order. and you try to hit the bench 9:00, 9:05. It's something. Sometimes things come up. You get late documents you have to look at and review. But after 10 minutes, you should be on the bench. That's kind of how I look at it.
So that brings you to your staff. So how important is your JEA and your law clerk? How important are those two individuals supposed to be for you to run a very productive courtroom?
Well, I can tell you this: my JEA has been with me on and off since 1986 or 87.
Oh, wow.
I mean, she's that good. She really and truly is.
86.
Absolutely, because we worked at the same law firm, the Gallus law firm, way back in the 80s. And she was my legal assistant in practice and those types of things. And she's very, very well organized. She really is. And she's really smart.
You want to give her a shout out?
Lynn, if you're looking. Yeah. But I mean, she's really good, right? But I look at her as my air traffic controller, right? And that's what she is. She's the air traffic controller because she gets the calls. And what's great about her, though, she understands a little civil procedure. She's really good at scrubbing cases and she actually, the only time she comes into court is when we're doing our calendar call, right? And she knows about ordering the juries. And you know what? You just can't give that type of job just to someone that doesn't have, I would think, some significant administrative background.
It's
dealing
a
with
huge
paper.
job,
It's a
actually.
huge job. It really is. And as far as law clerks are concerned, I have a different view on that. And here's my point. I've had 21 law clerks, right? I have.
Aren't you supposed to stay a law clerk for like a year and then take the bar or something like that?
Yeah, you do. But we had a couple of them that had opportunities where like they're 8 months in and they get a really good job offer, right? And I'm not going to stand in your way and say, no, you have to serve your year, because I can have somebody to come in later that could use that help working as a judicial law clerk. And so I let them go. And I don't mind saying it. I'm so proud of my law clerks in this one respect. All of them are doing really well for the most part. I think 19 out of the 21 or 22 or whatever it is, they're doing
Practicing attorneys.
Oh, yeah. In fact, one just became a partner at Woodsmith Henning, which is a national law firm. And that's kind of what you want, right? And one thing I try to do too is, I don't mind saying it, I kind of give preference to public school kids. I do, right? Because, they need a shot too. They need an opportunity because everybody couldn't go to Bishop Gorman or the Meadows, right? And so my point is this, and I don't mind telling everybody this. First thing I ask a law clerk candidate is this: where'd you go to high school? First question I ask them. Now, if they went to Valley High School or El Dorado or Rancho. Clark. Yeah, Clark. I consider that in my decision making, because they need a chance, and everyone, because you have to work hard to go to Clark and then go to college and go to law school, right? Silver spoons are typically there.
Yeah. Let me ask you guys a question. What do you think about the difference between having criminal versus civil judges?
What do you mean?
Like have a judge who just does criminal cases versus a judge who just does civil cases, and even more specialty courts within that.
Well, I can't speak for Jim. In my perspective, I think that whatever that bench offers, like Judge Williams is only on a civil calendar, so he should be an expert in that. Yeah. But when you have a dual calendar, I think that it might be a little bit confusing at times for a judge. To switch the hat. I think it might be. I think they have their civil hat on in a criminal case, right? And I think it's just confusing. I think that each bench should have a particular judge that handles civil, criminal. I don't think it should be a dual calendar, but there are some benches that do have dual calendars, and some judges perform well. But I think they could perform a lot better if they only had one mindset. Yeah, I don't know. What do you?
I agree. I really do.
Well, so do I. I do. Said it any better. That's exactly my position too.
Yeah. I mean, because you get in it because the law is so complex, and I don't mind saying it. I've never handled it.
The law is complex.
It's complex, man. And so you want, and the standards of proof are different in criminal cases versus civil cases, and all sorts of things. And I think one thing we've done very well here in Nevada, we have specialty courts, right? And for example, we have construction defect, which is a really complex area. And so we had a construction defect panel for years. The numbers have gone down as far as those cases are concerned, so the panel has shrunk somewhat. But then we have business court. And here's what's crazy about business court, and I don't feel everyone really understands how complex it is and why. But we have so much commerce going on in Clark County. And I'll give you an example. They have a firm called JAMS, which is the Judicial Arbitration and Mediation Service, right? And they have a big office here.
They got arms too.
They got an arm too, right? And the only reason I bring JAMS up is because they're international. They have offices all over the country. And I was talking to one of the representatives from JAMS, and I asked him a question. I said, look, I see you're just opening up an office in Phoenix, and I don't think you have one in Houston yet. Why? Why Vegas? And he said it's the type of cases we have here. With all the gaming and all the casinos and regulation, the best way to say it is Las Vegas punches way over its weight when it comes to complex civil litigation, way over its weight.
The reason I raised that issue, the dichotomy, because the Missouri plan is not something that can be enacted that easily here. It's going to take a constitutional amendment. But how and what type of cases judges preside over, that would probably more be administrative functions. So to me, that could be a solution where if you're going to still have an elected judiciary, you should be running for a business court. And now I can look at your background and see, oh, this is a person who has commercial litigation experience, as opposed to maybe a public defender who now becomes a judge in a certain type of specialty. Nothing wrong with public defenders or prosecutors, but they obviously have the criminal background and that mindset. And could they translate into being successful in a civil case? Some have, and maybe with others with mixed results. But at least for me as a voter, I can drill down a little bit deeper and see, okay, what kind of cases are you going to be presiding over? And then I can make a more informed decision about whether that person seems qualified.
Isn't that the policy of the court or the chief judge to make that decision of what department is what?
The departments, right?
Maybe if they streamline it and say, okay, departments X through B or A through D is
No, but what I'm saying is maybe if you run, you're forced to run for a specific department and type of court.
Yeah, I've always because that's usually 90% of the time when I interview judicial candidates. That's almost always my first go-to question is like, okay, why Department 2? Why Department like Q, our buddy? Why Department Q? And he walked around with his duck. Like, because the average person doesn't know.
Right. Yeah, they have no clue whatsoever.
And one really important factor, you talked about the duck. I mean, I don't know anything about that, but I'll say this. Temperament is so important too. You know, you
not to storm off. Speaking of Department 2, not to storm off the bench in a hissy fit. Have you ever done that, Judge?
No. No. There's really no reason to get upset. I remember one of my earlier law clerks, she looked at me and says, Judge, you know what you have? I said, what? She said, you have the velvet hammer. That's what she calls it. You know, she said it comes down soft but heavy, you know, and that's how it should be. And I look at it more of a confidence level. Why should I get upset? You know, and I don't mind saying it because if emotions get involved, you don't think clearly.
Yeah.
True.
You don't.
How long you had a civil calendar for?
Forever.
Oh, you've never done criminal?
Never.
Okay.
You know, and here's the thing though, I don't.
So you could walk around unarmed then. You didn't put nobody in jail.
I guess, you know, but
just take their money. Freeze that bank account.
Well, people get upset about that too, right? Maybe more upset.
Yeah, I was going to say that.
Because at least, you know, I guess people that commit crimes, they kind of know when they're innocent or guilty at the end of the day, right? Unless there's an emotional issue involved. But
when you start freezing bank account, taking property.
Money makes people crazy.
Oh, yeah.
It really does, you know. But
so, Mr. Jonas, do you have anything else you want to
one question for Paul. Present company excluded. But have you always been a supporter of the Missouri plan? Or did this just become an issue that you care about because you don't think that some of the judges that you go in front of should have been on?
So most of my professional career, I was in federal court.
Right.
And then when I started my own firm, I started coming to state court more frequently.
Right.
And now I would say the majority of my practice is in state court.
Right.
So I would say my view on the issue has evolved based upon my experience.
Right.
And what I've seen is that it just seems that the judges who get appointed seem to me to be often better. because they've been vetted and they've gone through a process. Now, as the judge said, there's no such thing as a perfect system.
Correct.
You can always find flaws in any system. But I think this is, in my opinion, a better system to have judges go through some type of process than just randomly pay a fee and all of a sudden any lawyer. I mean, I think the standard now is that you have to have been licensed for 10 years. And out of those 10 years, 2 of those years, you have to have practiced law in Nevada. But what if that person has been a terrible attorney, had all kinds of complaints, has never really handled cases of any real significance? They can become a judge. I don't think that's a good system. I don't think it benefits anybody. I feel that having a vetting process is very important. So I have completely changed my view on it.
You know, and especially because understand this. I mean, how often do you talk to your congressperson, right?
Yeah.
Or your governor? But if you
Last week I did.
Yeah, I was going to say the average person. Now, Steve and I are not the average people. About an hour before I left my house.
But most people don't do that. But
Right, correct.
let's face it, 50% of the people, 50+% of the people who get married get divorced.
True.
So they're going to have contact with a family court judge. A lot of people get involved in motor vehicle accidents. And so the judiciary for the average citizen impacts their day-to-day life more so than probably any form of government other than picking up trash or something like that.
And plus 70% of litigants in family court are improper persons.
Right. You know,
That's a very high number.
That's an extremely high number. And so you want to have a judge that has a sound temperament, that will listen and be fair. That's all you can ask for, right? And
I think the reason people are hesitant to give up our current system is that everyone feels that they have some control over it. I can vote against that judge. But that's what we've been talking about. With the Missouri plan, you do get that. You still retain that right under a system where you can retain or not. But I think
The only thing you don't do is put a judge in office.
correct.
right,
Yes.
you can take them
But
out.
you can take
Yeah.
them out.
You can take
But you can go to public hearings. I do agree with what you said, that there
Right.
should be a public forum.
Absolutely.
So then, you know, like let's say someone's running for judge right now. Unless I can run a commercial against them and afford to do that, who's going to listen, right? You as an average voter have zero say. But if you can show up to a hearing and say, well, let me tell you what my experience is with this person, you committee should consider this, that you actually now have more say in the system than you otherwise would be as a
Absolutely.
random voter.
And I'm going to bottom line it for you. This is kind of how I look at it, and this people can decide. But say you need a babysitter, right? Mm-hmm. And so you need a babysitter, and someone gives you a list of 10 names. And say, okay, pick a name. Or do you want someone to have some sort of vetting process before you are sent those names, right? Mm-hmm. Because if you don't have a process in place, you might like Ann Jones. She has a nice name, and this person might have an ethnic sounding name. But what do you do? Because you don't know who you're picking to come in and to be your babysitter. Mm-hmm. And to do that, that's not the best system, I think. Because at the end of the day, most Nevadans are going to be impacted in some way, form, or fashion by the judiciary.
You've evolved your views too, right? You realize that now that just saying someone is a Republican versus a Democrat is not the most efficient way to.
You and I had a real brief discussion because you were really busy that day. But because we were talking about, for instance, some of the candidates in the Republican primary and some in the Democrat Party primary, and you were like, so what do you think of so-and-so? And I'm like, hey, okay. They're a little left of center for me. A good friend of mine, Ruben Da Silva, he just got elected, and very proud of him. And I can tell you right now, we don't see eye to eye on a lot of issues, but I know he's a good guy. He's a person of character. Yeah. So I'm not going to ignore that just because he's a Democrat.
Right. Exactly.
And here's a good way to look at that. When it comes to the interpretation of a contract and the specific provisions that are incorporated in that contract, political party doesn't matter.
Yeah.
Or if you're looking at the law of negligence or the law of medical malpractice, none of that matters, right? The question is does the trial judge have a complete understanding of NRS Chapter 41A?
Yeah.
Right? That's what it comes down to.
That's right.
Because I'm not going to be making any decisions regarding your taxes, right? But if you have a medical malpractice case pending in front of me, you want a judge that understands what they call medical causation, right? That's what you want. Right. Paul?
That's true. I agree.
That's it.
100%.
Did we cover everything? Did we miss anything?
I don't have any more questions other than I greatly appreciate the
It's a
discussion.
good discussion, yeah.
Oh, yeah.
And a very
Paul, I'll
important
let you
one.
go first. Mark's going to zoom in on you, and you
No.
can say the final, your point of contact or whatever.
Paul Padda at paulpaddalaw.com. 702-366-1888 is the firm number. Anybody out there with questions or needing representation, give us a call. If I can't represent you, I can definitely steer you in the right direction.
Judge Williams?
And I just want to thank everyone for welcoming me down here today. I've enjoyed myself. Hopefully, it's been educational for the public. And last but not least, just give some thought. I'm not recommending any plan, but maybe change would be appropriate, maybe not, but at least be informed on the issue.
Yeah, good point.
Yeah.
Well, gentlemen, thank you so much for being on the program. Mr. Potter, thank you
Steve,
for
Jim,
showing
thank you
up.
very much. Yeah.
Judge Williams, thank you so much
It's
for
been
coming on.
a pleasure. I will say that.
And hopefully that this has educated people,
Yes.
or will educate, because it's going to be on the internet forever.
It's an important discussion. People need to know their rights.
They do.
Folks, thank you, Jim. Folks, we had a very, very awesome show with Nevada attorney Paul Padda and the Clark County District Court Judge Tim Williams on the Missouri plan on eminent domain, qualified immunity, term limits, and what was the other thing we touched on? Oh, remove and retain. We hope that everybody is informed or more informed than they were before they sat down and watched the show. This is Steve Sampson, Jim Jones for Veterans in Politics. Until next time.